Hi everyone, in this week's dispatch video we are focusing on constructive dismissal claims. In simple terms, a breach of an employee's contract of employment which results in them treating themselves as discharged from the contract so that they can pursue a claim against their employer. One of the key features of a constructive dismissal argument is the generally expected and held view that an employee should resign promptly in response to any fundamental breach of contract. The argument, if an employee delays, is that they have affirmed the contract, so accepted the breach and are quite prepared to continue with the employment relationship, and that can fundamentally undermine a constructive dismissal claim. So the Employment Appeals Tribunal were recently asked to consider this question in a case involving an academic at a university. So he'd been at the university for around 40 years, received a complaint from a student, and his allegation in a grievance to his employer was that the university had not considered those complaints sufficiently. The grievance was rejected. He was not happy about the way in which the grievance was dealt with, and that was made clear in June 2020 that they couldn't help him any further. So the next month he engaged solicitors to try and negotiate with the university, perhaps over an agreed settlement or perhaps to revisit the way in which they dealt with the grievance. Those talks broke down, and on the 7th of September the employee resigned and claimed constructive dismissal. Now, he was relying on the June 2020 date as the last straw, so the last in a series of incidents that breached the mutual duty of trust and confidence that's implied into every contract of employment. The respondent, the employer's view, was that he had delayed too long in resigning. If he identified that there was a final straw breach in June, why did it take him some 3 months to resign? And they'd said that, well, he'd affirmed the contract because he'd stayed and continued working over the summer. So before the Employment Tribunal, that was accepted. He then appealed to the Employment Appeals Tribunal and alleged, among other things, that the tribunal had focused too heavily on the passage of time between the last straw breach and his resignation. The Employment Appeals Tribunal disagreed with the tribunal's approach, so they focused on the fact that his 40 years of service was important to take into account. That would, in the context of a resignation, create a lot of upheaval and distress for someone that was such a long server. They looked at the work that he'd done over the summer period and considered whether that was of equivalence and significance compared to his normal role, and tried to come to a decision as to whether that meant that he'd affirmed the contract. Some interesting principles came out of the EAT, which I think are a little bit inconsistent with what we'd understood to be the current position of the law. So tribunals should not focus too much on the passage of time when considering whether affirmation has taken place. All the surrounding facts and circumstances should be taken into account. And in this case, the factors to take into account were length of service in particular. Somebody with such a long period of service may take longer to make a decision about their future and whether to affirm that contract and take the leap away from what would have been a very secure contract. And of course, part of the reason for the delay here was the passage of time due to negotiations taking place over settlement. It's relevant that the employee sought to try and resolve matters amicably in that way and give the opportunity for the university to put things right in their view. In that case, the matter was sent back to the tribunal to consider on a different assessment of the position. So it's important to stress that the affirmation test still applies. So an employee generally should act quickly in treating a breach of contract as fundamental, bringing that contract to an end and pursuing a constructive dismissal complaint. But we do have some principles on looking at the circumstances as a whole and, to the employee's advantage, potentially identifying some factors such as length of service, such as any period of negotiations, which may be of significance when determining whether that constructive dismissal argument can still proceed. If you do need any further advice on this or indeed any other employment matter, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.